everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. We are in the week before Thanksgiving in 2023, and there is a lot going on. We wish we could pick something like just one topic, but today we have many. We have the mistrial motion for Trump's civil New York trial that's happening. We have issues in Congress that we're going to touch. We also have the ethics rules that have come out from the Supreme Court, as well as some updates to the 14th Amendment, Section 3, that has been going on for trial in Minnesota and Michigan have released decisions, and we are still waiting on Colorado to determine who, if anyone, will actually remove Trump from the ballot. So, I'm Virginia Tarani. I am an attorney with Tarani Law, LLC, because you never need a lawyer. Until you do. And my co-host here is Dr. John Weil, who is the Dean of the Honors College at Middle Tennessee State University. Welcome, Dr. Weil.
Good to be here.
Okay, so we're going to jump in just a hot second, but it is the weekly wine. So here's the wine that I am drinking today. It is where I am. It's Maryland. I don't know, Dr. Weil, if it's the same for you, but I walked out literally in my Tarani Law t-shirt and felt fine today. And it's the middle of November, so I have pulled a summer wine out. We're going to continue with our Maryland wines, and I have Misfit Winery watermelon wine today. So we're going to continue to breathe in the last ode to summer. And Dr. Weil, you're there with your water, and cheers to happy hour in this week before Thanksgiving. Oh my gosh, it's like a watermelon Jolly Rancher. That's delicious. I'm going to try not to drink several glasses while we talk today, but our topics might induce it. Okay, so what we have, let's start off with Trump, because this week we have had a 30-page motion that got sent down or filed by Trump's attorneys in this New York civil fraud case. And in this document, he's included affidavits, he's included exhibits, and ultimately he is asking for the judge to disqualify himself, but in a different kind of motion. Dr. Weil, what's your take on this motion?
You know, I haven't actually read this one.
I don't know if it's even available to read. I haven't found it either.
Okay. What I was, if you purposely antagonize somebody over an extended period, you probably shouldn't be surprised that they're not going to always wink at you in your direction.
Fair.
My read this week is that, the judge clearly does not want to be overturned or have to recuse himself. And I think he opened the door. I mean, he basically opened the door to a 2 or 3 hour infomercial on the Trump name and the Trump brand.
Oh, my goodness.
And to have to just sit through that, to me, seems like he's making at least the appearance of being favorable. I mean, understand the judge has already made a decision, which is within his right within this case. They're just arguing right now over what the amount of the damages and the type of damages should be. Mm-hmm. So it seems like one of these things that's a little counterproductive if you know the judge is going to have to make the decision. But so my guess is that it is primarily for, although we don't have access to it, but it's primarily for public consumption rather than in the expectation that anything is actually going to happen.
I completely agree. I like the way that you phrased that and described it, especially at the end, because that seems to be what is happening with the trial. Is it's shock and awe and almost a circus display of, I think they're playing to the public.
Right.
They're not playing to the judge. They're not playing within the court rules necessarily. They're playing for public attention and opinion. And the judge was very clear on that as well, is, this is not something you should be doing for public opinion. And the interesting part that you bring up is how much there was basically an infomercial. But this week, Donald Trump Jr. took the stand again.
Yeah.
on the defense side, the defense started their case this week, and he was their first witness. And that's exactly what he did. For about 3 hours, as I understand it, most of his commentary or his testimony was more like commentary of, this is fabulous and we're amazing. And, the Trump brand is, he kept using one word over and over. Do you remember what the word was? I'm racking my brain for it.
Oh, like spectacular?
Yes, I think that was it.
Yeah.
Exactly, where he kept using it over and over as spectacular, and everything's spectacular. And by the time that there was an objection...
if you were testifying on behalf of your dad, I'm sure you'd say the same thing.
Fair enough, and that's hilarious. And for those of you who haven't picked it up through this season, Dr. Vile is my dad. And of course, all I would say is, you're spectacular. That is a really funny take. I don't think many judges would allow me just to continue to say you're spectacular, but this judge did, right?
He did. And what's fascinating about this is it points ahead. And it gives some caution. There's another legal issue here, which is, this trial is not publicized.
Right.
And I think there's great fear that particularly in the election interference denial trials, that if they are televised, we will really have sort of a sideshow. Rather, we'll move out of the realm of law into the realm of public opinion.
Right.
And, there's going to be some leakage there, and people need to know what's happening in the courtroom. But given what happened on January the 6th, there is real danger in some, it's not quite related, but you may have seen yesterday, the Democratic National Headquarters, they had to evacuate people out of there because of, this was Israel and Hamas, that situation. Sure. But, some of these things, if publicized and you give too much of a platform for disinformation, you really could result in, that, and we have a gag order right now being considered in Georgia.
Yes.
And that involves, leaking, as I understand it, affidavits or actually videos of the three or a couple of the three. I
think it's 4 now.
Right, who have, turned state's evidence against Trump. And the danger there is that, this could invite recriminations against them. I was seeing something yesterday that Senator Romney, who's now retiring, apparently has to spend $4,000 to $5,000 a day right now for his personal protection.
Oh my goodness!
And if that becomes the case with witnesses, that could really influence a trial in a negative fashion.
I agree. And for this Georgia, it is quite scary because I've been watching it too, and what's happened is that those videos, and I believe it's of 4, and especially Chesbrough, Sidney Powell, and Jenna Ellis, those videos where they are talking to prosecutors, telling them what evidence they have, what information they have, and would testify to, was given by the prosecution to the defense attorneys, the remaining defense attorneys,
which they have to share inculpatory or exculpatory information.
Well, they have to share exculpatory information, which is anything that might tend to, cause innocence to be, that might prove them innocent rather than proving them guilty. And in this case, I think it's wise that it's being produced, even if the prosecutors don't think it's exculpatory evidence, because it might be, right? It absolutely could be used. That testimony could be turned, rephrased, questioned by the defense counsel. That could be more, proactive and positive for certain defendants. But it was shocking to me when they had this video conference and one of the attorneys for the remaining defendants, one of the Georgia defendants, and I didn't look up the name, I'm afraid, but it wasn't one of the top ones, and it wasn't Trump. And this man says, before you say anything else, Judge, I have to admit it was me. I have to tell you so that I can sleep at night. And I did it, and I thought I was doing it in the best interest of the public because I thought they had a right to know, and I thought people needed to know the innocence of my client. And that's when that's the discussion of the gag order. And I got to tell you, it's almost, to me, an ethical issue where I would not be surprised if the Georgia bar initiated investigations into this attorney for leaking the videos to the Washington Post.
Even though there's not a gag order? I mean, did he do anything illegal, or but you're saying he may have done something unprofessional.
Correct.
Even if it wasn't illegal.
Correct. It's possibly, depending on the rules of ethics or professional conduct in Georgia, it could violate one of those. At the very least, what you're saying about the possibility of intimidation of witnesses, and, possible destruction or corruption of evidence, I think that it is possible by leaking these videos that there is an intimidation of witnesses. That, look, it's going to be publicized throughout the whole United States if I testify against Donald Trump or any of these other witnesses. I don't want to do that. So I think it is a big concern. And one of the other defendants, the defendant who spent time in jail, was the only one who didn't get bonded out and later did. He has new posts, social media posts, about the poor women at the poor women at the election who were have been alleged to be tampering with evidence.
Critical of them.
Exactly. Exactly. And it's still posting of, how they're fraudsters and how they, tampered with the evidence.
He needs to look at the Dominion case involving Fox News.
For defamation.
Yeah, absolutely.
And so the prosecutor's office, in addition to seeking the gag order, even on the attorneys, they're now seeking return to jail, revocation of bond on this one man because of what he's saying, that he's still intimidating witnesses, that, more people are getting threatened, more people are feeling threatened, and even, Mitt Romney. But we go to, did you see the scariest thing to me, quite frankly, was the reposting on Truth Social that Donald Trump did regarding I believe it was the Attorney General, Letitia Jones, as well as Jack Smith. Did you see that?
I didn't. What distressed me, and I don't remember if we talked about this last week, but, and it does have legal ramifications, was Trump's Veterans Day speech, in which he threatened to root out, and I'm quoting almost verbatim, communists, socialists, right-wing fascists, and other vermin.
Vermin, yeah.
And this is a term that was used in Nazi Germany in the 1930s. You dehumanize. Understand, I'm not in favor of communists.
Of course,
I have a little, or fascists. But when you start putting people into your categories rather than their own, and dehumanize, talking about them as less than human, you really create, a bad situation. And that was sort of combined with speeches suggesting that we will have our revenge.
Yes.
If you vote for me, we're going to get, it's sort of a continuation of the locker up theme from the 2016 election,
right?
And
with Hillary Clinton,
it's a very peculiar dynamic, because I can see how Trump's supporters would say the Justice Department has been weaponized against him.
Sure.
From my perspective, if they took a long time doing it. And they seem to be giving him legal due process. So I don't consider that to be what's happening here. But by claiming that the Justice Department has been weaponized against him, it's basically, this is going to be tit for tat.
Yeah.
If this is what they, if they're coming after me, when we get in office, we're going to come after them. And that, you expect Attorney General is appointed by the president, and the president's a member of a party. And you can hardly expect the the president to appoint someone he thinks is going to be a thorn in his side. But that being said, plenty of presidents have let attorney generals continue with actions that have not been particularly favorable to them, because they did accept, the laws, the depiction of justice is justice as a blindfold around their eyes.
Mm-hmm.
You're not supposed to have, special favor toward one side or the other. And I fear that he's really contributing to this attitude of the law as an instrument, instrument to oppress or get back, rather than an instrument to determine justice.
I agree. And with those words, I agree. It's very concerning. And we've even got the words where many of his comments are to say that racist so-and-so, and names the attorney in Georgia a racist. Now the attorney in the New York fraud case, he's named a racist. And then add that together with rigors, and we're instituting base dehumanization, this base almost rejection of an entire class based on phraseology that you would use, on the playground, like you don't have any, they're meanies.
Or
let me come up with bad words.
During World War II, people referred to Japanese, with a shorter, people did this for African Americans at one time.
Yeah.
And the results are never good.
No. Well, it even reminds me, and I don't know, here I am with poor history recall. Was it Rwanda where it was the one side, it was, the cockroaches, they called them cockroaches.
Yes.
And over the air, day after day, the radio speakers were going with, we got to kill all the cockroaches. We got to step on them. We've got to weed them out.
And that's exactly what happened in Germany. You pick out the Jews, and then you attribute everything that has ever gone wrong to Jews. And the next thing you know, they're in concentration camps.
Right.
So, you mentioned the language, and this maybe make a good transition to Congress.
Sure.
So this last week, now it's not altogether new, and I told you I was going to do this, but we got to talk about something that happened on May 26th of 1856.
Yes.
And Senator Preston Brooks of South Carolina was upset that Charles Sumner, a fellow senator from Massachusetts, had accused one of his relatives, if I recall, of basically having a mistress, an ugly mistress that was beautiful only to himself, and the mistress was slavery.
Oh,
and so,
no.
So it was highly inflammatory. Sumner had used highly inflammatory language. But remember, particularly the Southern culture at this time was what's known as an honor culture. Now, in an ordinary circumstance, if he had directed this directly to Preston Brooks, the Southern code would have called for each of them to get a pistol and go out somewhere and have a duel. But because Brooks did not consider Sumner to be a gentleman, he decided instead to sneak up on him with his cane and begin beating him in the head. And resulted actually in serious injury to Sumner that I think was with him for most of the rest of his life. And the good news is we're not there yet. But this last week, we had at least 3 incidents which seem to indicate that tempers are very frayed.
Yes.
And of course, what we already know, which is that Congress is very, very closely divided between Democrats and Republicans. Legislation, of course, requires both houses of Congress and either a presidential signature or, voting over
the veto.
Over a veto. And 3 incidents, I guess the funniest, and the one that I think I would have turned around. One of the senators or members of Congress referred to a witness as a Smurf. And, remembering my own daughter's love for Smurfs, I probably would have taken that as a compliment, but I don't think it was meant as a compliment.
No.
And then of course we have the 2 Republicans, Kevin McCarthy and I should
Senate,
know because pardon?
The leader of the Senate.
Yeah, no, this is the House.
Oh, sorry.
Kevin McCarthy, the former speaker.
That's right. I'm so sorry.
I don't know that we have film of it, but there seems to be confirmation that he elbowed a Tennessee Republican in the kidneys, and they had a dispute as to, whether this was chicken or, what kind of behavior this showed and how pitiful it was and whatever. So we had that little exchange. And then let's see, what was the other was we had a Senate hearing in which a senator who apparently had been provoked by a labor leader who sent a number of missives out referring to him in derogatory terms. He stood up and said, "You indicated you wanted to have this out. Let's do it now."
Oh my goodness.
And, the witness said, "Bring it on." And Bernie Sanders is there hitting his hammer down, trying to keep, 90-year-old, however old he is, trying to keep order. It was fairly funny if it were not behavior being engaged in by
the
US
leaders of our country
and a labor leader as well. I mean, I'm not going to excuse either one of them for the behavior, but it really shows how fragile we are. And, it's not a good sign going into the next presidential election. Our local newspaper, not local, Tennessean, comes out of Nashville, has had a series of attempts through the last year or two, try to publish articles on civility and the need for civility. And one of the fascinating things about this was until the proposed fist fight, there were many people who were doing what I had done, which, political scientists, the House is bigger, it's closer to the people, they have 2-year terms,
right.
They don't have to be quite as old. And you sort of expect that the House is going to be a little bit more unruly than the smaller, more elite, longer term, somewhat older members of the Senate. But it looks like it's happened now in both houses. And so hopefully people will step back a little bit and say, the dignity of my office prevents me from responding in an appropriate fashion to what you have just said.
Right.
But, I would ask you to refrain from name calling and, let's discuss this in as reasonable a fashion as we can.
Yeah.
We sort of hinted at this when you talked about the Georgia attorneys. There are laws that have penalties, but there are also norms.
Right.
And often the norms, which are not necessarily codified and are not necessarily physically enforced,
right,
are sometimes more important. Character, how we treat one another may be far more important than what the law, a law against murder. Okay, it'll provide penalty for somebody who kills me, but I'd like some other laws. I'd prefer people not spit at me as I go down the street.
Right.
I don't know if that's against the law or not. Maybe it is. It might be a form of assault or battery. But nonetheless, even if there weren't, I would prefer to be in a society where that's just something particularly ladies and gentlemen would not do.
Right.
You might expect it. It's fascinating how many comparisons there have been to high school behavior. And then commentators have said, well, this is, we've now descended from high school to junior high.
if not preschool. I mean, I'm thinking of the jungle gyms and the playgrounds. It's like, I know you are, but what am I? I know I am, but what are you? Whatever it is, it feels like there's so much just name calling and offensiveness toward other people. And, I don't always like to, as much as this is a legal program that talks about politics because they're in the law right now,
right.
I try not to express too many specific personal opinions, but I have to say with regard to civility, I think my own respect level would have been higher for Trump had he, whether the election was rigged or not, had he been able to say, you know what, I think it was rigged. I don't think it was right. I don't think it was fair. But you know what? That's okay. We're going to accept it. And we're going to use the next 4 years to build us up stronger and better than ever before so we can win the next election.
So what is the expression, the fish rots from the head down,
Oh, I don't know.
or
I
something
haven't
to
heard
that
that.
effect? Which is, I do think that more than any contemporary president, Trump as president really lowered the bar for acceptable name calling behavior and the
Right.
like. And I think, I think it has, well, worked its way down. Um,
Yeah, well, we're even, and I'll circle this back real quick, is the call through one person who he reposted on his media platform this last week of, there should be a citizen's arrest of these two attorneys. And the idea of Trump reposting that, and the idea of his, people who really believe in him would go out and try to do a citizen's arrest of these people is quite scary.
it is.
So many
It
things go
is.
wrong with any kind of citizen's arrest. It needs its own little podcast. It's such a weird piece of the law, but the idea for calling for that at all and
Well, and a
having people
citizen, I mean,
believe
I
that.
think a citizen's arrest, you'll know the law better than I do, but it is usually like in a situation of imminent danger, right?
Yes.
Or, I mean, it's not this person's, needs arresting because they're they have
Correct.
the
Though
wrong opinion.
it is an idea where citizens arrest can occur when there is a true belief and understanding that a law has been violated, that they have, broken the law in some way. And what the allegation is these people have broken, not just gone after Trump, but broken the law in some way. So they need to be arrested. No one within the government is doing so. So we as citizens now need to rise up and do it. And that is a very scary proposition, considering there have been death threats to various prosecutors and judges as a result of decisions that have been made. So it's just, for me, a call to peace. Peace and civility, and no matter what we think our opinions are of other people, ultimately they're people too.
Well, and here's why we have this behavior. Part of it, maybe it's the Trump influence, maybe it's, the character of the times.
Right.
But part of what's happening is most of these people are getting publicity.
Yeah.
And they're spelling their names right. And a year from now, we're not going to remember what the event was. We're going to remember, well,
Them.
my member of Congress has been in the news a lot.
Yeah.
He must be really influential. And again, I've used this term before. We got a lot more show horses than we do work horses.
Yeah.
And I'm fairly suspicious of anybody who appears on television once a week or so, like this podcast.
But I'm suspicious too.
but always for some other sort of provocative thing that they've done. The provocateurs, they're getting attention for the sake of attention rather than apparently for the sake of adopting legislation or serving their constituents.
Well, I have to tell a story, and then we're going to pick up the Supreme Court ethics and then a final update on the 14th Amendment issue. But here's my fun story that I've been thinking about all week with this, filing this mistrial motion, all of the antics that are going on, the soliloquies in the courtroom, the support and the spectacular news on Donald Trump. I think back to when I was a prosecutor in Newport News, Virginia, and there was this one defense attorney who I loved him. He was absolutely great, but he was a show horse. He looked like the Monopoly man purposely. So people would know who he was, would recognize him immediately. He wore the gray pinstriped suits. He had the mustache and the beard. A lovely gentleman. He and I became great friends, but he really would put on a show in the courtroom. And that's why defendants liked him and hired him, is because he was, extravagant and extraordinary. And it looked like he was doing everything he could to help the defendants. And for the most part, I agree that he was. He was a great attorney. But I had a trial with him once where it was a bench trial, not a jury trial. And he was there, waving his arms and being boisterous and, this amazing speech that anyone from the hallway could hear. And the judge, I'll never forget, looked at him and said, I won't use his name, but Mr. Attorney, would you like for me to lower and dim the lights for you now? And I'll never forget it. It was hilarious.
That's good.
And the man was, of course, saying, are you saying that I'm not being serious? And he's like, no, I just want to get you the lighting that you need. Oh my gosh, it was so funny. I wish I could have had a record of it. But that's kind of how I feel with this trial is, let's dim the lights and put a
there's
spotlight.
a case where maybe that behavior didn't work.
It is.
Because if I were the judge, if you try to respond in kind, you would have been unlikely to be able to put on the same kind of show.
Absolutely.
But the lack of a show could actually contribute to the judge thinking one side's taking it seriously and the other is not.
Yeah, and I mean, we won.
These behaviors can backfire.
Right. I agree. So speaking of behaviors and pretty poor behaviors, we know that there have been issues with especially Clarence Thomas on the Supreme Court this year. What is it, Roberts? Who's the other one that it's come up with? Alito. Okay. I'm just so focused on Thomas because it does seem shocking, the behaviors that he's done, especially with regard to receiving gifts, for using gifts, for getting a lot of money.
And a lot of it has to do, I'm not so much sure that it has to do with receiving gifts, although that's part of it, as it does with concealing.
Right, with not disclosing it.
Right, the failure to disclose. And, there's an implicit, when I know somebody has purposely hidden something, that leads me to believe that they realize that maybe it wasn't quite up to snuff when they did it.
Right. And it has been concerning.
And in fairness to Thomas and Alito, the rules have been, well, there's really not been as I understand it, there's not a formal has not been a formal code for the justices in the same manner there have for other judges. And, the typical standard, which is mentioned, by the way, in this statement that they came out with, the typical standard for a judge is far and above that you would require for a senator or representative, thank God.
Or even a regular attorney.
Right, which is, it's not just you have to avoid wrongdoing, you have to avoid the very appearance of wrongdoing.
Yeah, the appearance of impropriety.
The appearances right now, it appears as though particularly Thomas has accepted a lot of very big gifts from some very wealthy people. I don't think there's been an allegation that the people who've given him large gifts have necessarily been defendants before him.
Right.
And so that gives him a little bit of leeway here. But it's still, if we knew that a member of Congress was receiving gifts and then having to vote on matters that even indirectly related to somebody who gave the gifts, it would, we worry about campaign finances.
Right.
And that's typically not a direct gift to the candidate.
Right.
It goes into for a particular cause.
It smells like a bribe. And it's not. Legally, it's not, but it smells of it. It feels of it. So I'm glad somebody's doing something about it. Congress has wanted to, and the Supreme Court has rejected that idea, but they have come up with their own.
Well, to stop there, some members of the court, Alito in particular, has said that he doesn't believe Congress can adopt an ethics code for the court. I'm not as confident that they can't. I mean, I don't know why they would not be able to adopt a code if they wanted to. And I think the court would be very wise in such a case to stay out of it, and not be judges in their own case, which is what they would be.
Right.
But probably to preempt the possibility, all members of the court, by the way, signed on to this statement, a code of conduct, which
is great.
Well,
we've never had it before. Yeah, it is great on paper.
Yeah, I mean, there are many of the principles there about disclosure and gift giving, and they exempt books, by the way, which any scholar has to like. And frankly, most justices, what justice has ever written a book that at least 10,000 people didn't buy it just to see, if nothing else, lawyers who might appear before them. So they have a good way to raise money. But here's the problem. So I want to go back to, I told you I was going to do this, right?
Yes.
John Locke, one of the greatest English philosophers, believed to be one of the most important influences on America's founding fathers.
And
wrote
especially even the Declaration of Independence.
Well, there's surprising that the traditional view, yes, is that the Declaration of Independence reflects what's known as Lockean natural right philosophy. There are, ever since Gary Wells wrote a book in about 50 years ago, arguing that Scottish common sense philosophy also played a pretty big part in that. But in any event, John Locke wrote 2 treatises of government, among other things. And in his second treatise, he described what we call is a sort of a theoretical construct, a state of nature. What would life be like if we had no government? And you know that this was, before him, there was an English philosopher named Thomas Hobbes,
right,
who concluded that in the state of nature, the life of mankind would be solitary, poor, nasty, brutish, and short. And Locke comes along and he says, well, it's not quite that bad.
It's not that bad.
People would still have some moral intuitions. We'd still know, we're all God's creatures, so we'd know generally right from wrong. But he said it would still be an inconvenience to be in the state of nature. And he gave 3 reasons that we would want to get out of a lawless state. And they are that, let's see, the lack of a known and settled law. So, we'd have some, natural law, but as we know, people interpret natural law differently. So, lack of a known and settled law. This seems to sort of get to that. Okay, we're now giving our standards. But what it lacks is the 2 other deficiencies. One is the lack of a known and impartial judge to settle disputes. And the third is the lack of a power to back and support the decisions of law. So we have a code that the justices say we're going to follow. And in my judgment, it's better than the press is giving it. There's some good things in here.
I agree.
But we don't know. The court, for example, seems to say recusal is still up to the individual justice. And they actually give some arguments for it, which is if the rest of the court could decide to recuse somebody, they might gang up in order to help their side.
Oh, interesting.
But, they don't really tell us who can you go to find out, if you didn't know whether accepting this gift was appropriate or not, who would you go to find out? And they don't specify
who to interpret it and who to enforce it.
Right. What would the penalty be? Who's going to enforce it? So it's sort of like we have 1 of 3 elements needed to get out of the state of nature. And so we will see. Now, the one possibility that I've thought about, but I'm not sure how it would work out, it's possible that you could enforce it by impeachment.
Oh, interesting.
You could say, and all 9 justices have signed this thing. All of them have agreed to a code of conduct, and having agreed to the conduct, we believe X justice failed to do it. Now, the question is, well, it might be bribery, wouldn't be treason, but would that be a high crime or misdemeanor?
Right.
To violate something that you've agreed to do, but that isn't otherwise legally enforceable. And
it doesn't seem like a crime or a misdemeanor because it's not breaking of a law.
Right. Plus which we've only had, test your knowledge.
Okay.
Who's the only Supreme Court justice who was ever formally impeached?
I do not know.
Samuel Chase. Happened during the Jefferson administration. You ought to remember that.
I remember
from personal experience, right?
Yeah, you were there. You tell me.
But he was, now to be clear, there have been other lower federal judges who have been impeached and convicted and removed from office. Chase was impeached but not convicted.
Sure.
And no other and there have been threatened impeachments against William O. Douglas, Earl Warren, and others, but none of them succeeded. So I don't know. I mean, I think it is a worthy first step, but it's still sort of, it's the Supreme Court, but it's like saying the president is above the law because he's the president. Just because you're the Supreme Court, okay, maybe you have a little bit different rules, and
Right.
I don't know who should enforce it, but there ought to be something with a little bit more teeth in it than this seems to have.
Yeah, fair enough. No, I agree. I think it's a good step, but in the end, it feels meaningless.
And part of it
is retroactive? That's the other question. Is if somebody chooses to try to enforce it, is it retroactive? Where even Alito or Thomas's behaviors could be looked at in terms of this new document, and then impeachment attempted.
It's sort of like, what is, I'm trying to get the expression, the gate's already open and the horses are out of the barn.
Oh, right. The horse is already out of the barn.
Maybe it will stop future, but does it allay concerns about, current justices?
Current and past.
And again, what worries me about it, I don't necessarily think that Thomas or Alito have flouted the law, but they seem to have not had sufficient attention to the institution that they're representing. And the institution is far more important to me than this or that individual justice. And
absolutely,
they're potentially, even if it's not wrong, if it has the appearance of evil, then it's undermining the authority that they need to enforce the law in other areas.
Absolutely. Yeah, I agree. Okay, so I know you have one more thing about, I believe, the amendments in a book.
Oh, yeah.
And then we're going to finish up with the 14th Amendment trials.
Yeah, I know the the reading public, and is that visible?
It's okay. So I have to look down to look at it. Hold up just one. Oh, there. It's a little bit. Yeah, I know. You've got the blurred background. That's a little better. The picture's a little better.
It's a 2-volume work. That's what I want people to know. 5th edition of my Encyclopedia of Constitutional Amendments, Proposed Amendments, and Amending Issues 1789 to 2023.
Amazing.
By Bloomsbury.
Okay.
All my presses keep buying one another out. It used to be ABC Clio. Now it's Bloomsbury. Tomorrow, who knows?
ABC Clio not exist anymore?
It does, but this particular, they divide it. They do different divisions, and
interesting. Because I've grown, growing up with you, all I saw was ABC Clio everywhere.
Well, I did a lot with Prager and other Roman and Littlefield, other publishers too. But go with the flow. They did a good job with it. I like everyone so far has had the Capitol building, but each has had a somewhat different picture, so that's good.
Well, I love it. And everybody check out, we are putting links to the biographies for Dr. Weil, his curriculum vitae with Middle Tennessee State University, where you can actually see many of the books that have been published and the books and works he's contributed to. We're also putting a link for me and then for our other co-host, Chelsea, who's on with us every once in a while. So you can check out the newest books. You can check out our biographies, see a little bit about us. And then let's finish it up with the 14th Amendment. You and I have been doing this for a number of months now with this.
We got on it like a week or two after the first article was published. So.
We were on it like a hotcake. Hotcakes, I don't know. That other expression.
We kick on a dog or something.
But I'm glad we were, because I think we have been at the forefront. Sorry about that. Been at the forefront of this issue and have been following it very closely. And this is, as a quick update and summary for those of you who may not know, is there's Section 3 of the 14th Amendment, which basically says that you cannot hold office if you have been a supporter of insurrection or rebellion, or if you have given aid or comfort to people who have engaged in insurrection and rebellion. Read it for yourself. The Constitution is actually quite interesting reading. But it's on my bedside with the Bible, right?
Justice Harlan. Do you know that story?
No.
Justice John Marshall Harlan I from Kentucky was said to go to bed to sleep peacefully every night with a copy of the Constitution and the Bible under his pillow.
I love it. All you need. All you need. So there's this idea that was first published by some law professors, and then also confirmed or affirmed or supported by another law professor and a former judge. And it's really sparked some interest as to whether Trump can be said to have engaged in insurrection or rebellion, or supported and given aid to those who have. It has ended up in court where we predicted. We're still predicting that it's going to end up in the Supreme Court. But 2 states, Minnesota and Michigan, this last week have decided essentially that it's a political question. The timing's not right. We don't have authority to make a decision as to whether this statute, so to speak, this clause and provision can prevent Trump from being on the ballot. This is too early. The time is not ripe. It appears to be a political question. But Dr. Weil, you had an interesting theory on it that I like, and I would like for you to expand on for our listeners, is the idea that even though it's not yet ripe, when people say it might be ripe for review, may be too late.
Right. I mean, and one of the things actually that Trump has argued, as I understand it, is if this is to be decided, it should be decided after the election. And that in some ways would be the absolute worst time.
Right.
Because, if you think back to Bush versus Gore, and, there's still very divided opinions on that. Mm-hmm. My own opinion is it probably would have ended the same way even if the court hadn't intervened. I'm not sure that's a majority opinion.
Right.
But however that may be, to say what kind of court would want to step in if, in fact, let's say Trump were to win both the Electoral College and the popular vote, what court is going to step in after the American people have voted and say,
and he's in,
but he had no business being on the ballot, so we're going to invalidate it. So
right.
I suspect now, and then I want to modify something you said, because I'm not sure that I think this will ever get to the Supreme Court.
Oh, interesting. So you're changing your mind.
Well, particularly if it gets postponed, it would only come up if Trump were to win the election.
Okay.
And I personally think that's problematic. He has yet to win the national popular vote in 2 elections. He looks up in the polls right now, but it's a year before. We don't know for sure that he's going to get the nomination, nor do we know for sure that Joe Biden is going to be running again.
Right.
So, there's a possibility it would get to the court, but I think the court would have. I think they would have greater reluctance to intervene after the election than they would if one of these cases came up to them right now.
Right.
This would give people due notice in a way that, because think about it, okay, if you disqualified, let's say Trump were legitimately elected, and he were then disqualified.
Right.
Who would then be president? I'm assuming that his vice president, who's yet to be named, probably not going to be Mike Pence.
Right.
He would take over, but how many people, really want the vice president to be president? If they wanted him, they would have nominated him as president rather than. So I think it's high. I think in January, it would almost surely be declared a political question.
Yeah, and
I believe we have another state or 2 to go.
Yes.
If he is excluded, let's say, from the Colorado or Arizona ballots, then I think there would be a good chance, and I think that would be the time, particularly given what's happened, if you have, because you would essentially have divided circuits, right? Or
a split circuit opinion.
Because we've had 1 or 2, and I don't know if it's at the circuit court level yet, but we've had 1 or 2 courts who've declared we're not going to intervene because we don't think it's appropriate. if one or two other courts ruled in the other direction, then it might be time for the court. I would actually prefer them to come in then.
Yeah.
Although, again, it could be misinterpreted, right? The court, I'm sure if the court said we consider this a political question, Trump would immediately say, I've been vindicated by the Supreme Court. It would go sort of like the Mueller report. The Mueller report didn't indict me, so therefore I must be innocent, which would not, necessarily be true at all, but that would be potentially how it would be interpreted.
Yeah, no, I agree with that. And it's definitely something to watch. It's still in Colorado. So Minnesota and Michigan said no. You're right. In Colorado and Arizona, we're still waiting. Now, this one's being published on Thursday night. So Wednesday was the conclusion of that trial for the amendment issue. It may come out before our podcast is published, in which case, it's still, I think our opinions are still interesting, but it's wait and see. And hopefully we'll update you next week on what happens in Colorado and possibly Arizona. But Colorado is close. They closed their case on Wednesday.
Well, one of the fascinating aspects of this is it shows the difficulty of constitutional interpretation.
Yeah.
Because the words seem pretty clear, but we know the immediate intent was to prevent people who had sided with the Confederacy from reestablishing themselves in office and reinstituting, if not slavery, the black codes and some of the other repressive legislation at the time. So you have something of a conflict between what the plain words seem to say and maybe what the original intent was, although maybe they were farsighted enough to say, well, the Civil War won't be the only time in history where people challenge legitimate government, and this should apply now and forever.
Right. We still have treason laws. They're still used.
Absolutely.
Even recently within the military, some concerning patterns there.
Yes.
But all right. Well, thank you for talking with me today. Very, very excited about all of these topics. Very interested in all of these topics. And
can we say one other thing?
Please do.
I mean, Thanksgiving, right?
Yes.
So we are thankful to live in America.
Yes.
We're thankful for family and friends and country and Constitution. I have this wonderful jug at home that you probably know. King and Constitution. Well, we don't have a king, but
not officially.
It's right. It's nice. It's nice to be in a country where, at least for now, we can discuss these things and do it in a civil fashion.
Yeah.
Maybe turkey's supposed to make you sleepy, right? Maybe the best thing that could happen is maybe we should have this giant turkey feast for members of Congress. And see it, force feed them if needed, hoping that it will somewhat lower the tone. Everybody fall asleep instead of threatening to fist fight one another. I'd fight you, but I'm just too tired. Don't feel like it.
Don't save the Thanksgiving turkey. He's got to be sacrificed for Congress.
Exactly.
Well, we'll do that. And that reminds me, thank you, that we will not have a podcast coming out next week for Thanksgiving. We are going to take some time off to be with friends and family. We hope that you are too. So happy Thanksgiving. We'll keep you updated, possibly even on social media. So check us out if you haven't already at The Law Unscripted. We're on YouTube. We're on TikTok even. You can even find us on Facebook and LinkedIn. Stay for updates for those things, even when we aren't videoing, and we will get back to you the first week of December. Thank you, Dr. Weil, and happy hour and Thanksgiving to all of you.